Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. So, interpretation of statutes class. In this small video, we are going to discuss the presumption against ousting of jurisdictions. Presently, in this video, we are going to discuss the presumption against the ouster of established jurisdiction. Established jurisdiction includes creation of new jurisdiction. So the presumption. You all know Section 4 of the Indian Evidence Act deals with may presume, shall presume, conclusive proof. So this is regarding the presumption. May presume means you may presume or may not presume. Shall presume means you have to presume until it is rebutted. Conclusive proof, you don't have any other option except to conclude with the same. Now coming to the point of jurisdiction. What is jurisdiction? There are two words, juris dicta. Juris means by law. Dicta means I am saying. I am authorized to say by law because I am having the authority. Please remember, jurisdiction means the authority one can exercise. That's why I always say, I've been telling example. The principal district and session judge Ongole, presently Srimati Madam Bharati, so she can exercise the jurisdiction in the Prakasham district only, erstwhile Prakasham district only, not in Guntur district because our jurisdiction is only required. Then present point is who will decide the jurisdiction? Please remember. So jurisdiction is bestowed in the court by legislation, not by the court. In the class I asked you people and you said court will decide the jurisdiction. No. The legislature, the government in power, they will decide the jurisdiction. Legislation can only take away the same. Please remember. For example, previously Andhra Pradesh in 2019 it was having 13 districts. Now they have been reorganized or amalgamated into 26 districts. Alright, so district jurisdiction, who has to give jurisdiction? Present government. As far as the so-called legal jurisdiction is concerned, since they are not divided. Still, Chirala cases, Chirala is now in Bapatla district, but Chirala cases are being tried in Ongole itself. So jurisdiction has to be decided by the legislature only. First point. Second point, by mutual consent, you cannot create jurisdiction. You cannot exceed jurisdiction. You cannot take away the jurisdiction. Then example enti, the dispute is regarding a land at Kandukur. But both the parties are staying at Ongole. I am either Ongole or property Kandukur lo unna. Actual jurisdiction ikkada Kandukur lo veyali. Unna మేమిద్దరం ఒంగోలు ఉంటున్నాం కాబట్టి రోజు కోర్టుకి మేమే తిరగాలి కాబట్టి వీ వాంట్ ఒంగోలు కోర్టు జ్యూరిడిక్షన్ అంటే ఒప్పుకుంటారా? నో. సో బై మ్యూచువల్ కన్సెంట్ యూ కెనాట్ క్రియేట్ ఎనీ జ్యూరిడిక్షన్. సో దిస్ ఈస్ ది బేసిక్. రిమెంబర్ the presumption regarding jurisdiction is legislation is the competent authority and by mutual consent you cannot oust away or take away jurisdiction. Now case laws. And I forgot to tell you, jurisdiction of the High Court and Supreme Court, since they are constitutional courts, they are decided by the Constitution. Please remember. Now, case of Srinivasa versus State of AP 1971. In this case, the special officer determined the average of cash rent per acre to the Rai Party lands solely on the basis of RSR, settlement register. But Supreme Court held that the special officer has an obligation under Section 2 of the AP Estates Land Reduction of Rent Tax Act 1947 to determine the cash rent. Here, the jurisdiction of the so-called special officer is not only RSR, but it is also having effect on the so-called AP Estates Land Reduction of Rent Act. You have to look into that. So the rent cannot be excluded and jurisdictional civil courts cannot be excluded. So please remember, here as far as the rent is concerned, please remember judicial courts, normally you can't say that you can't go to the court. They can approach the court of law. Second, Madhav India versus Union of India, 1971. So this is regarding abolition of privy purses. So the question is on the legality of the abolition of the privy purses, right? So Supreme Court said the exclusion of jurisdiction. So previously they used to enjoy their own jurisdiction. It is emphasized by non-abstentive clause. That means notwithstanding anything contained in the Constitution, notwithstanding anything contained in the so and so. Yes, the state under Article 373 and 363. Under Article 363, yes, the state can enlarge the field of the so-called exclusion of judicial authority. Therefore, privy purses accepted. Since you have been enjoying the land for a long time, yes, I am giving you monthly this remuneration. Accepted, please remember. So, jurisdiction of the court cannot be excluded where a relief is founded under Article 362, personal rights. This is a limited bar, but anyway, the jurisdiction in this class we have to emphasize on only 2 points. The jurisdiction will be decided by the legislature or the government. By mutual consent, you cannot take away or you cannot create the jurisdiction. And the officer who has got jurisdiction, he can only deliver the award, he can only deliver the judgment, not the others. If you know this much, it is sufficient. Thank you.